Hello, everyone, and welcome to today's presentation, the second in the Empower Hour series, Housing Rights and Concerns for People Living with Cancer. This presentation is intended to give general information, and even though I'm a lawyer, it is not intended as legal advice, and there is no attorney-client relationship. There will be time for Q&A after the presentation, and that part will not be recorded. However, this is being recorded and will be available on the Cancer Legal Resource Center YouTube page. I also welcome questions during the presentation if they would be beneficial for the group. One last thing, I want to say that I hope that I will be able to answer your questions, but there may be instances I might have to tell you I don't know it, either because it's not information I have offhand or it might be too specific for today. However, I encourage you to fill out an intake with us so that we can properly research the information. The CLRC stands for the Cancer Legal Resource Center. We are a program of the Disability Rights Legal Center. The CLRC provides information and resources to people affected by cancer, including patients, survivors, caregivers, and healthcare professionals. Our resources are free, regardless of income. People often ask, what does cancer have to do with the law? This is a list of some cancer-related legal questions. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. On your screen, you can see the list of all the webinars supported by both the Tower Cancer Research Foundation and by CGen. We are very grateful for your support. And as you can see, we have more in the Empower Hour series. The CLRC has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and practice area. Now, you saw a little bit earlier the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All that the attorney agrees to is a half-hour consultation, just 30 minutes. It's very easy to apply, and we have an upcoming free CLE event. The CLE is pending in June. It's called Mindfulness for the Legal Mind. We hope that you can join us. The link is on your screen. If you would like to view our resources on any number of topics related to cancer, please visit our website. Educational webinars like this one are recorded so we can later put them on our YouTube channel for you to share with anyone who may want to learn more about a variety of subjects. If you have questions about today's presentation, please type them in the chat box. I will be leaving time at the end to answer some questions. And as I had indicated, that part of the presentation will not be recorded. However, if you have questions about your specific situation or someone you know has a question you want to ask about, please fill out our online intake form at clrcintake.org, as you can see on your screen. After you do so, we can research laws and resources for you and provide you with free customized resources. Everything is confidential. With the generous support of the American Cancer Society and Breakaway from Cancer, the CLRC has a revised version of the Patient Legal Handbook. The handbook provides an introduction to the most common legal issues that a patient diagnosed with cancer is likely to face. It is available to download for free online in English or Spanish by going to our website, theclrc.org. Providers can request copies shipped to their offices. Having a safe place to live is important for everyone, but especially for those who are coping with a cancer diagnosis. We're excited to get to the fundamental parts of the presentation, which will cover the following topics. And the first one is federal housing laws. There are several laws that protect people with disabilities from housing discrimination. These laws typically work with each other and cover different issues, and some of the issues that these laws address include architectural or structural access, effective communication, and policies and procedures. Section 504 states that no qualified individual with a disability in the United States shall be excluded from, denied any benefits of, or be subjected to discrimination under any program or activity that either receives federal financial assistance or is conducted by an executive agency or the United States Postal Service. Each federal agency has its own set of 504 regulations that apply to its own programs. Agencies that provide federal financial assistance also have Section 504 regulations covering entities that receive federal aid. So requirements common to these regulations include reasonable accommodation for employees with disabilities, program accessibility, effective communication with people who have hearing or vision disabilities, and accessible new construction and alterations. Each agency is responsible for enforcing its own regulations. Section 504 may also be reinforced through private lawsuits. It is not necessary to file a complaint with a federal agency or to receive a right to sue letter before going to court. So as you can see on your screen, the Section 504 of the Rehabilitation Act of 1973 prohibits discrimination on the basis of disability in any program of activity that receives that federal financial assistance. So most local housing authorities do receive federal financial assistance. This includes provisions for physical upgrades of certain dwellings in limited circumstances. Title II covers all activities of state and local governments, regardless of the government entity's size or receipt of federal funding. Title II requires that state and local governments give people with disabilities an equal opportunity to benefit from all their programs, services, and activities. For example, public education, employment, and transportation. State and local governments are required to follow specific architectural standards. And so, as you can see, it does prohibit discrimination on the basis of disability in all programs, services, and activities provided or made available by public entities. And complaints of Title II violations may be filed with the Department of Justice within 180 days of the date of discrimination. In certain situations, cases may be referred to a mediation program sponsored by the department. The department may also bring a lawsuit where it has investigated a matter that has been unable to resolve violations. The Federal Fair Housing Act makes it unlawful to discriminate in the sale, rental, or financing of homes because of race, color, national origin, religion, sex, familial status, or disability. Fair lending prohibits lenders from considering your race, color, national origin, religion, sex, familial status, or disability when applying for residential mortgage loans. Fair lending guarantees the same lending opportunities to everyone. So under the Fair Housing Act, it is illegal for your landlord to interfere with any of your fair housing rights, whether it is by use of force, threats, or by intimidation. And it's important to also say that there are examples of discriminatory lending practices. For example, a lender commits discriminatory lending practices when he or she acts on the basis of these categories such as race, color, national origin, and disability in one of these following manners. For example, refuses to make a mortgage loan, imposes different terms or conditions such as different interest rates, points, or fees. So any lender, real estate and mortgage broker, appraiser, loan service, and title company can commit lending discrimination in any phase of the mortgage loan process. The Federal Fair Housing Act prohibits housing discrimination on the basis of disability, among other classes that I had mentioned, in private housing, housing that receives federal financial assistance, and state and local government housing. It is unlawful to discriminate in any aspect of selling or renting housing or to deny a dwelling to a buyer or renter because of a disability. This also includes financing, as I discussed, zoning practices, new construction design, and advertising. It also requires new multifamily housing with 4 or more units to be designed and built to allow access for people with disabilities. So this these laws are out there in order to protect you, whether you're renting or seeking a mortgage. And when I talk about disabilities, I just want to be clear that under the law, any physical or mental disability that substantially limits one or more major life activities. So certainly cancer can be considered a disability under the law. Does, for example, a question comes up, does the person with the disability need to be the renter or the person who signed the lease or the mortgage? No. Any person that is associated with you that will be living in the unit cannot be discriminated against under the Fair Housing Act. So just an example, for example, if the housing unit was ready for occupancy after March 13th, 1991 and has 4 or more units and has an elevator, the housing unit must have, if there's a common area, it must be accessible to people with disabilities. Doors and hallways must be wide enough for wheelchairs. So there are other provisions covered, but that's just to give you a sense. Title III prohibits private entities that own, lease to and from, and operate places of public accommodation from discriminating on the basis of disability, and requires places of public accommodation and commercial facilities to be designed, constructed, and altered in compliance with established accessibility standards. So one other aspect is that there has to also be a reasonable accommodation. According to the U.S. Department of Justice, a reasonable accommodation is the change, exception, or alteration of a rule, policy, or service that may be necessary for a person with disability. To demonstrate that an accommodation is necessary, there must be an identifiable link between the person's disability and the accommodation that is being requested. So let's talk a little bit about the difference between a reasonable modification and a reasonable accommodation. A reasonable modification is a structural change that is made to the premises. And we just had talked about a reasonable accommodation. An example from the U.S. Department of Justice of a reasonable accommodation is that a housing provider has a policy of providing unassigned parking spaces to residents. A resident with a mobility impairment who is substantially limited in his or her ability to walk requires an assigned accessible parking space close to the entrance to their unit as a reasonable accommodation. There are available parking spaces near the entrance to the unit that are accessible, but those spaces are available to all residents on a first come, first served basis. The provider must make an exception to its policy of not providing assigned parking spaces to accommodate this resident. For example, a landlord with a no pets policy may be required to grant an exception to this rule and allow an individual who is blind to keep a guide dog in the residence. And the Fair Housing Act also requires landlords to allow tenants with disabilities to make reasonable access modifications to their private living space, as well as to common use spaces. The landlord is not required to pay for the changes. So, when can someone make a request for a reasonable accommodation? Requests for a reasonable accommodation can be made during any stage of the housing process, which includes the application, the tenancy, and to prevent eviction. Does a housing provider have to do anything that you request? No. When making a request for a reasonable accommodation, it must be reasonable, meaning that if the request fundamentally alters some aspect of a program or the request creates an undue financial or administrative burden, the housing provider may not have to comply with the request. Who pays for the reasonable accommodation? If the units were made available for occupancy after March 13th, 1991, and they do not comply with the Fair Housing Act standards, then the tenant may have a case against the landlord. If the units were made available for occupancy before March 13th, 1991, then the tenant may request modifications. However, the tenant would have to pay for the modifications. Now let's look a little bit more about asking for accommodation and modifications. Submit requests in writing or, for example, email. Attach supporting medical documents. It's a good idea to keep those copies. When mailing documents, send by certified mail and request a return receipt. That way a landlord cannot claim that they didn't get it if you have a return receipt. If they claim that you never sent something, you have that certified mail certifying that you mailed it. If the landlord has misplaced documents, you have a copy of those documents. And it's a good idea to submit it in writing, whether it's email or a letter, so you do have proof and you're able to really think about how you want to express your request. So the question comes up sometimes, do I still have to pay rent if I have cancer? So as we discussed, the issue of reasonable accommodations may come up. In fact, if someone has not had cancer before and then they have cancer, they may not have needed any accommodations. But then when they sign the lease, for example, but then they do. Cancer can change the circumstances of someone's situation. It can also affect not only in terms of an accommodation to the physical premises or the apartment, it could also affect someone's financial situation. So, how does this come up? Well, what if someone with cancer unfortunately loses their job and cannot pay rent? If you know in advance that you will be unable to pay your rent, talk to your landlord immediately to work out an agreement. If you are unable to make arrangements with your landlord to delay your rent payment, then you should make arrangements to leave the unit as soon as possible, giving your landlord written notice. You can be held responsible for paying the rent for a full 30-day notice period, whether or not you are in the unit, and could face the same issues mentioned above for breaking your lease early. Your landlord can give you a 3 to 5 day notice to pay rent or quit regarding on the state in which you live, unless other arrangements are made. If you fail to pay the rent within 3 days, your landlord can file an unlawful detainer complaint or eviction against you in the local court where the property is located. Your landlord cannot lock you out of your apartment or shut down your utilities or other services for your failure to pay your rent. If your landlord kicks you out, you may sue your landlord for committing a self-help eviction, but you may be locked out by the marshal if your landlord wins the case in court. So what if you get sick and need to move out of the apartment? You must notify your landlord in writing as soon as you know you're going to move out before the end of the lease term. And depending on the state, there might be certain allowances that do provide other support. However, this is a national webinar, so I would certainly urge anyone that may be facing this situation to contact the CLRC if to find out if their state may allow you to break your lease if you suffer from a qualifying physical disability that requires you to live somewhere else. Most laws require you to let your landlord know that you need to break your lease in writing within a specific time period before you need to move, ranging from 30 to 60 days. You will likely need to give your landlord proof that you have a qualifying condition that requires you to live somewhere else. Even if your lease or state law does not technically allow you to move out early, your landlord might be willing to negotiate with you. You may be able to find a new tenant or help your landlord find a new tenant, depending on your lease agreement with your landlord. So certainly, if you have trouble paying rent, first step, look at the terms of the lease. Then contact the landlord immediately to work out an agreement or try to delay the rent payment. After all, you signed the lease, so it is really important before you talk to your landlord to understand what the lease allows you to do or not allow you to do, so you can make sure that you're on the same page. If it is not possible, and sometimes, unfortunately, the situation after someone is diagnosed with cancer, things have to change quickly. If it is not possible, then give the landlord written notice of intent to vacate and make arrangements to leave. And certainly a landlord may allow a former tenant's assistance in finding a new tenant to take over the lease and potentially reducing the tenant's responsibility. That might not happen, but it is worth a shot to raise that. If you leave before the end of the lease, you might be responsible for the remaining rent due under the lease, plus any reasonable expenses the landlord has in finding a new tenant, minus any rent the landlord can collect from a new tenant between the time you leave and the end of the lease term. Your landlord may have a duty to minimize their losses, mitigate damages, depending on your state's laws. Now, it might be that you're surprised for the better in that you only have 1 month left on your lease and it's something that could be worked out, or some arrangement can be made. So again, it is important to look at your lease, to contact the landlord immediately, and to try to work something out. If you need to break a lease early because you're unable to pay rent and need to move out for medical reasons, unfortunately, there is usually not a clause in the lease that allows it to be broken for medical reasons, and usually not a law that allows one to do that. However, it might be a good idea to examine the lease to make sure whether you do or whether you don't, and to enlist a landlord-tenant attorney's help. Also, sometimes if a lease doesn't state that it doesn't allow subletting, that could be an option as well. And as I discussed before, negotiating with the landlord might work as well. Now, on your screen, you see a list of states that allow someone to break a lease if you suffer from a qualifying physical disability. If your state is not on the list, you can definitely still contact us. Laws are changing, and certainly we saw during the pandemic that there were additional laws out there to protect people during that time. And of course, the laws are designed to protect people that were unable to pay or other circumstances. That includes people with cancer and people that do not have cancer. So certainly it is a good idea to reach out to the CLRC based on your specific situation so we can research the state law for you. Now, I briefly mentioned an eviction, and I just wanted to go over that. Hopefully you'll never ever have to deal with an eviction, but it is worth just going over it so that you have that information if you're either being threatened with an eviction or you think that one might be happening to you or to someone you care about. So first of all, proper notice. The landlord must provide written notice to the tenant of default. Then unlawful detainer, that is a special court proceeding to evict a tenant. A court hearing. In most jurisdictions, after the landlord files the required paperwork, a court hearing on the unlawful detainer will be set, and then finally landlord possession. If a writ or court order is issued, it is executed by local law enforcement. So let's move on to making repairs. So here we go. Constructive eviction. Now, we talked about eviction a moment ago, but this is something different. If property has been neglected, residents may have the right to vacate a property that is uninhabitable. This occurs when a landlord does not physically or legally evict a tenant, as we saw previously, but takes actions or fails to act in a way that significantly interferes with the tenant's use and enjoyment of the premises. For example, a tenant can no longer use and enjoy the property due to a landlord's actions, such as the property does not have electricity for an extended period of time. A mold situation is not addressed in a reasonable time. Toilets do not work for an extended period. And the tenant gives landlord notice of the problem. Now, again, if you have a mold situation, it is your responsibility to let the landlord know, because if they don't know, they can't do anything to help. The landlord continues to fail to resolve the problem, and the tenant vacates the premises in a reasonable amount of time after the landlord fails to solve the problem or resolve the problem. Now, I really want to go over service animals. The Fair Housing Act, it applies to condominiums, and and there are even greater protections on service animals in the housing context. So persons with disabilities may request a reasonable accommodation for any assistance animal, including an emotional support animal. This is both under the Fair Housing Act and Section 504. If a landlord has a no pet rule, a person with a disability can request an accommodation in writing, including a note from the doctor or therapist verifying the need for a support animal. And then a landlord may not require an applicant or tenant to pay a pet fee or security fee as a condition for allowing the assistance animal. Can individuals with disabilities be refused access to a facility based solely on the breed of their service animal? No. A service animal may not be excluded based on assumptions or stereotypes about the animal's breed or how the animal might behave. However, if a particular service animal behaves in a way that poses a direct threat to the health or safety of others, has a history of such behavior, or is not under the control of the handler, that animal may be excluded. If an animal is excluded for such reasons, staff must still offer their goods or services to the person without the animal present. That's, for example, if you enter a store. Can service animals be any breed of dog? Yes, the ADA does not restrict the type of dog breeds that can be service animals. So it is important to recognize that a service animal, which can be especially helpful to someone with cancer, there would be a way to get an assistance of that animal. I really want to touch upon asking for accommodations. We have done presentations solely about medical marijuana. So certainly if this topic is of interest to you, please contact the CLRC or check out previous programs that we've done. And I just want to briefly touch upon this because we bring this up because it is possible that someone affected by cancer may need to use or may decide to use medical marijuana for the purposes of managing their symptoms. There is a conflict between states that have legalized medical marijuana and even recreational marijuana, and then federal law. So certainly, if this is something that you're looking to pursue, it would be a good idea to contact the criminal defense lawyer and find out just what are your rights, what can you do, what can you not do, and then certainly from there, you may seek to request an accommodation to smoke um, medical marijuana, and it's something worth looking into. Nuisance. I also another topic that is worth raising. Harm must be substantial, usually according to an ordinary individual, unless a neighbor knows of a particular sensitivity. So just going a little bit more into depth about a nuisance, um, a private nuisance which occurs in housing situations is a civil wrong. When analyzing whether or not an act is a nuisance, courts look to the person's conduct and the level of interference with the enjoyment of the premises. So the person creating the nuisance would be the defendant, the person being harmed is the plaintiff, and the harm has to be substantial. So trivial annoyances will not be considered a nuisance. The standard is normally assessed by an ordinary individual. So if someone is doing something that most ordinary people wouldn't find problematic, it most likely will not be considered a nuisance. And the exception to this is when someone knows that their neighbor has a particular sensitivity and chooses to continue. If your neighbor does something maliciously, then a different standard for a nuisance will apply. So that brings us to something that some people may certainly consider to be a nuisance, and that would be tobacco smoke. So for example, just going off of what I was saying before, if someone knows that you're sensitive to smoke and purposely blows smoke towards your window, there may be a cause of action. However, you will need to prove that your neighbor had knowledge of your sensitivity and the potential harm the nuisance would cause. So things such as construction, as long as they're during business hours, are not presumed to be a nuisance. However, nuisance ordinances for construction are city ordinance specific. So if this is a larger issue for you, check with your municipal government for more information. So getting back to tobacco smoke, this certainly is something that could bother someone who has cancer, who doesn't have cancer. It can be very disruptive to someone. So practically, what steps can you take? First step, it could be a good idea to talk with your neighbors and just try to work something out. Uh, Secondly, check your lease to see if smoking is allowed. And certainly there are, depending on where you live, there might be restrictions on smoking beyond just the lease. But just if, as a first step, you can check your lease, see if there are laws in your community that apply to secondhand smoke in a multi-unit housing. That could be also very helpful, even if your lease does not cover it. And it's also a good idea to talk with your landlord, property manager, or homeowners association. So even if you're not a tenant, but you're living in a condo, talk to the homeowners association about the smoke problem in your apartment, condominium, or home. Your landlord or property manager may try to fix the problem by plugging underneath your door or sealing cracks in your walls. This may solve the problem temporarily, but most likely not permanently. You may want to ask to move to another unit or ask your landlord to implement a non-smoking policy in common areas. So those are already two solutions that could potentially be helpful. You may not need to move out of the entire location, rather just potentially move to another unit. A non-smoking policy in common areas would likely be something that others would support and would be something others would be really glad to have. Now, when we talk about being able to pay rent, I want to touch upon just the issue in a little bit more depth and really try to connect it to those affected by cancer. Sometimes there's simply not enough money to go around. If bills continue to come in after a cancer diagnosis or debt continues to rise, one thing that can help alleviate a bit of the burden, at least temporarily, is to prioritize the most important expenses. So, for example, and I'm by no means a financial expert or a financial advisor, but just to give a brief overview, if someone has debt that has been secured with collateral, such as a mortgage or a car loan, it may be important to prioritize those expenses or risk repossession or foreclosure. If you stop paying a car loan or mortgage, you risk losing your home or your car. However, maybe you live somewhere with excellent public transportation and other transportation options like Uber or taxis, and maybe in that case giving up a car isn't as big of a deal, or maybe the household can get by with one car instead of multiple cars. Along the same lines, even if you do not own your home, it is important to pay attention to due dates for other essential things like rent for an apartment. We often hear from patients and survivors who are struggling with housing issues because they stopped paying their rent or mortgage when their medical bills started piling up. We, of course, think of medical bills as necessities, but in a lot of circumstances, patients are still able to continue receiving care despite large bills, and may have a lot more flexibility with respect to repayment timing and options compared to a rent or a mortgage payment, where a landlord or bank may not be as flexible. It is important to be able to pay copays when you go to the doctor, and you cannot be turned away if you cannot afford them. But if you risk losing your home or your car, you may want to prioritize those expenses over, for example, a credit card bill. And again, based on your specific situation, not telling you not to pay bills or not to pay medical bills, but based on your specific situation, look at what you need to prioritize if you don't have enough money to go around, knowing that you can't just wish a bill away. It will still be there. But in the meantime, you can prioritize certain expenses if you need to. A home is the biggest purchase most people will ever make. Buying a home is an important personal and financial decision and often requires careful planning and saving. When someone becomes ill with a disease like cancer, this can have a substantial impact on their financial situation and ability to pay for expenses, such as those associated with home ownership. Foreclosure is the legal process reserved by a lender to terminate the borrower's interest in a property after a loan has been defaulted. Foreclosure processes are different in every state. It is important to learn about your state's foreclosure laws and processes. Generally, mortgage companies start foreclosure processes about 3 to 6 months after the first missed mortgage payment. The U.S. Department of Housing and Urban Development recommends contacting the lender to possibly arrange a repayment plan that would be based upon your current financial situation. However, mortgage companies are not required to work out a new payment plan. Now, this might have been a problem that you've never faced before. You may have very well been bought a home when your financial situation was completely different, not having cancer, not having any financial challenges. So you knew that you would be able to make those mortgage payments, even if there was a slight difference in terms of your ability to pay. However, just because you have just because you have a mortgage doesn't mean that you won't get cancer. And so if there are really high payments required for medications, for treatments, and the bills keep piling up and you're concerned about your ability to pay a mortgage, and you might be facing foreclosure, it is certainly worth contacting the lender and trying to work out a payment plan, even if it's ultimately not successful. It changes might need to happen due to changing circumstances. So how does the foreclosure process work? The law governing foreclosures may vary depending on where you live, but a lender usually forecloses on a home in 3 steps. Now, again, not saying that just because someone has cancer and high medical bills that they will necessarily have a foreclosure. We hope that this will never happen or you'll never even have to think about it. But again, it is worth knowing what is out there so that if, as you're contemplating decisions, as you're prioritizing expenses, you can really get a sense of what could potentially happen and what the steps are involved. So, first of all, missed payments. When a homeowner is having financial difficulties, they may begin missing mortgage payments. When this occurs, the loan becomes delinquent or overdue, and the homeowner goes into default. If you're in default, you should contact your lender right away to try to work out a way to make up the payments you have missed. First month missed payment. Your lender will contact you by letter or phone. Second month missed payment. Your lender is likely to begin calling you to discuss why you have not made your payments. It is important that you take their phone calls. Talk to your lender and explain your situation and what you are trying to resolve. At this time, you may still be able to make one payment to prevent yourself from falling 3 months behind. Third month missed payment. After the third payment is missed, you will receive a letter from your lender stating the amount you are delinquent and that you have 30 days to bring your mortgage current. This is called a demand letter or notice to accelerate. If you do not pay the specified amount or make some type of arrangements by the given date, the lender may begin foreclosure proceedings. They are unlikely to accept less than the total due without arrangements being made if you receive this letter. You still have time to work something out with the lender. Fourth month missed payment. Now you are nearing the end of time allowed in your demand or notice to accelerate letter. When the 30 days ends, if you have not paid the full amount or worked out arrangements, you will be referred to your lender's attorneys. You will incur all attorneys' fees as part of your delinquency. So as you can see, attorneys' fees can add up. It is a problem you hope to avoid. After being in default for 3 to 6 months, the lender will contact the homeowner to see whether they can pay their debt and will also file a notice of default with the county recorder's office. The period of time after a notice of default has been filed but before the foreclosure is final is called pre-foreclosure. Now, hopefully you don't get to the next step, but if the homeowner does not pay the debt or correct the default within a certain amount of time, usually 3 to 9 months, the lender will choose a day to sell the home and give the homeowner a notice of sale. The notice of sale will also be posted on the property, filed with the county recorder's office, posted online, and printed in newspapers. On the day chosen by the lender, the home will be auctioned to the highest bidder, who will then be given the deed to the property. This is known as the trustee's sale. If no one buys the home at the auction, then it becomes what is known as real estate owned, REO, and the lender takes ownership of the home and tries to sell it through a local real estate agency. Sheriff's or public trustee's sale. the attorney will schedule a sale. This is the actual last day of foreclosure. You may be notified of the date by mail, a notice is taped to your door, and the sale may be advertised in a local paper. The time between the demand or notice to accelerate letter and the actual sale varies by state. In some states, it can be as quick as 2 to 3 months. This is not the move out date, but the end is near. You have until the date of sale to make arrangements with your lender or pay the total amount owed, including attorney's fees. Redemption period. After the sale date, you may have the right to enter a redemption period. Redemption is a period after your home has already been sold at a foreclosure sale when you can still reclaim your home. You will need to pay the outstanding mortgage balance and the costs incurred during the foreclosure process. Many states have some type of redemption period. You will be notified of your time frame on the same notice that your state uses for your sheriff's or public trustee sale. State laws vary, so please contact a landlord tenant attorney for information about your rights. So, what should you do if you're facing foreclosure? Foreclosures can cause your credit score to drop by more than 100 points and can make it difficult for you to borrow money, find housing, or even change employment. If you're facing foreclosure and you do not enter a forbearance period, repayment plan, or loan modification, the following options might have less damaging impact on your credit score. Selling your home. You may be able to avoid foreclosure by selling your home and paying off your mortgage. You may be able to sell your home and avoid foreclosure even if the amount you owe your lender is greater than the amount of the value of your home. This is sometimes called a short sale. Your lender may agree to let you make a short sale if you're at least 2 months delinquent on your mortgage payments, are able to sell your house within 3 to 5 months, and meet additional housing and urban development guidelines. If you believe that a sale is your most realistic option, you should speak with your lender and start looking for a buyer as soon as possible. Most lenders will not postpone the foreclosure process to wait for you to find a buyer for your home. Deed in lieu of foreclosure. This option is where you voluntarily give the deed for your home to the lender in exchange for the lender releasing you from your mortgage debt. This option is for those who want to avoid foreclosure if you cannot sell your home through a short sale. It will not allow you to continue living in your home, and it will still cause your credit score to drop. However, a deed in lieu of foreclosure will not be as damaging to your credit score as you would going through the foreclosure process. One way to use the equity in your home is to convert your home equity into cash through a reverse mortgage. So this is certainly if you want to get additional money to support your treatment. For example, a reverse mortgage or home equity conversion mortgage, HECM, is a type of loan designed for seniors 62 or older whose home is their only property and either own their home outright or have very little left to pay on their mortgage. When someone takes out a reverse mortgage, they can receive a loan for up to half the value of their home and may receive this money in monthly payments, a lump sum, or as a line of credit. A reverse mortgage may be appealing because you do not have to pay the loan back as long as you are living in your home, and because the money you get from reverse mortgage can be used to pay off debts and improve the quality of life. However, reverse mortgages typically have higher fees and interest rates than other kinds of loans, and you must continue to maintain your home and pay property taxes. If you move out of your home for more than 12 months, you immediately become responsible for paying back the entire balance of the mortgage to your lender. If you live in your home for the rest of your life, your family or whoever you name to be in charge of your estate will be responsible for paying back your reverse mortgage loan once you pass away. In this case, this means that your estate will need to sell off or auction off your home to pay back the money you borrowed. This can be especially hard for couples who take out a reverse mortgage but only have one person's name on the reverse mortgage. If the spouse who took out the reverse mortgage dies or moves into a nursing home or facility, the remaining spouse will have to repay the loan immediately. A reverse mortgage usually only makes sense if you do not have any other assets, you think you'll be able to live in your home for the rest of your life, and do not want to leave your home to your children or other family members. An estate is a term for all the money and property left behind by someone who has died. All right, so here are some alternatives to taking out a reverse mortgage. They include taking out a home equity loan or a home equity line of credit. These are loans in which your home is used as collateral to allow you to borrow money. Some people prefer these options because the amount of interest you pay on these loans is tax deductible up to $100,000, and because in most cases you will still be able to pass your house on to loved ones when you die. However, if you default on these loans, Your lender could still foreclose on your home. A less risky option might be to sell your home and downsize to a smaller home that is easier and less expensive to maintain. If you choose to do this, you could use the money from the sale of your home to buy a new home and potentially have money left over to help you live more comfortably. If it is important to you that your home stays in your family, you could even consider selling your home to your children or other family members. So, mortgage refinancing. A lot of this information is hopefully you don't have to memorize it all. It will be available if you want to view it on our YouTube channel later. And hopefully by breaking it down, it will be less intimidating for you just to consider all the options. Refinancing is when you apply for a secured loan in order to pay off another different secured loan against the same assets or property. A mortgage refinance is a new loan that pays off and replaces an old mortgage loan. Since mortgage loans are not typically amended, a refinance mortgage is the easiest means of restructuring mortgage debt. Typically, home refinancing is done when you have a mortgage on your home and apply for a second loan to pay off the first one. When taking the decision to go for the home refinancing option, it is important to first determine whether the amount you save on interest balances the amount of fees payable during refinancing. The application process for a mortgage refinance is very similar to what someone experiences when they purchase a home. You consult with the lender, you have the home appraised, complete a loan application, and supply the required documentation to verify your home and assets. You do not have to pay closing costs, but they should be lower than they were when you purchased the home. When the refinance mortgage funds, the new lender automatically pays off the old mortgage lender, including any prepayment penalties, and transfers any remaining funds to you. The old lender releases its claim on the home, and the refinance lender files a new one. Now, we do get questions about subsidized housing, so I would just like to briefly touch upon Section 8. So there is something called a housing choice voucher program, and it's also known as Section 8. It is a good idea to search your local housing authority listings for options. The Housing Choice Voucher Program is the federal government's program for assisting very low-income families, the elderly, and the disabled to afford decent, safe, and sanitary housing in the private market. Since housing assistance is provided on behalf of the family or individual, participants are able to find their own housing, including single-family homes, townhomes, and apartments. The participant is free to choose any housing that meets the requirements of the program and is not limited to units located in subsidized housing projects. Housing choice vouchers are administered locally by public housing authorities, PHAs. These PHAs receive federal funds from the U.S. Department of Housing and Urban Development, HUD, HUD, to administer the voucher program. So PHAs may establish local preferences for selecting applicants from its waiting list. So it's certainly something to consider if given your circumstances. And it's a good idea if you have cancer to check for financial assistance according to your cancer diagnosis, and certainly contact the CLRC for housing resources. And speaking of housing resources, so we are the CLRC, the Cancer Legal Resource Organization. So of course, any presentation, we'd have to have some resources for you. And on your screen, you can see the Neighborhood Assistance Corporation of America Home Save Program. And it is a nonprofit housing and urban development certified organization, and it provides solutions for at-risk homeowners, including financial support, technical assistance, and training for revitalization efforts. So I'll just pause for a moment for you to take that name down. And again, this presentation is being recorded, so you will be able to access this information and go to the website. Here are some more resources. The National Fair Housing Alliance, a consortium of fair housing organizations that advocates for equal opportunity in apartment rental, real estate, mortgage lending, and homeowners insurance markets. And finally, the Hope for Insurance Hotline. It's a toll-free national hotline that offers free foreclosure prevention and counseling advice from a third party. Housing and Urban Development certified not-for-profit network of counseling agencies, and they're dedicated to helping homeowners avoid foreclosure. Now, when it comes to credit counseling, we have resources for you. So one of them is the National Foundation for Credit Counseling, and it offers counseling, debt management plans, money management education, homeowner counseling and education. And I had mentioned the U.S. Department of Housing and Urban Development, HUD, and you might hear it as HUD. You didn't know what those letters stood for. However, the website is easier to remember. Some of the other websites are a little bit longer. It's hud.gov, and you can find rental assistance, file discrimination complaints, and get information about home ownership. So we have reached the end of the presentation. Please remember that if you have any questions that are specific to your situation, you can call the CLRC or fill out an intake form. You don't have to do both. We will get to you, and we will be happy to help. And I just wanted to thank you for participating in this presentation. Your time is very valuable, and I'm so grateful that you spent this time with me today. And the CLRC's contact information that I referenced about contacting the CLRC, the website is on your screen, 1-866. The CLRC is the phone number. And so hopefully these are two ways that you can contact us, and we'd be happy to help. We also on our website have previous presentations, including the previous Empower Hour, which links to our YouTube page, as well as you can sign up for future Empower Hour webinars and future webinars as well. So thank you so much. I'm now going to stop the recording, and I will take any questions that you have.